Hello again, students. Happy Friday, April 10th. If you're keeping up with your work, that should be the day that you are watching this video. I'm going to try to keep it short for you. The agenda for today, you are going to be looking at this PDF right here that's linked both in the agenda slides and in the course modules right here called illegal viewing. It's a specific case that has actually occurred. You're going to read through the case facts. You're going to consider your answers to these questions. And then in Canvas, you're going to post for me your answers to the questions. I'm not looking for a novel here. I just want to know your thoughts. So be clear, be concise, explain what you mean. The next thing you're going to do is you're going to take a look at this video. So hopefully you've actually already done the case analysis, but if you haven't, make sure you do. And you're going to take a look at this video on the sentencing process and jurisdictions. Like I said, I'm going to try to keep this one brief for us. Okay, sentencing process. Here are the steps in sentencing an individual after the person has either pled guilty or been convicted by a court. The very first thing, and you do want to know that this is first, is that a probation officer, who is a corrections officer, is going to compile a report called the pre-sentence investigative report. The text that I don't make you read, it calls it the PIR. Some jurisdictions here in Illinois and in Kane County call it the PSI, pre-sentence investigation. Either one, PIR or PSI, you can call it. I'll put that in here so I don't forget that I told you. But that is the very first step. And that report includes absolutely everything that a judge would need to know in order to deliver a fair and a just sentence. So it'll compile everything there is to know about the case, everything there is to know about the victim, about the offender, everything there needs to be in there in order for the judge to do informed discretion. We'll talk more about how much discretion they get here in a minute. The second step then is once that report is compiled, the attorneys are interviewed, both the defense and the prosecution, and each side gets a chance to review this report to, number one, make sure that it's accurate, and number two, make sure that there's nothing in there that's prejudicial, nothing that would slant the judge's opinion too far one way or the other. So they have an opportunity to look at it on behalf of the people, if you're the prosecutor, or on behalf of the defendant, if you are for the defense. After that, each side attorney can petition the judge directly for a specific sentence. A lot of times this is done if they've reached a plea bargain and the person has pled guilty. Notice here that the prosecutor is the one who has the power. They are the ones who are going to most influence the judge when it comes to having decided a plea bargain, because if they didn't agree to it, it wasn't a bargain that was actually made. And sometimes that causes the disparity in sentencing. And we'll talk more about disparities later, but basically that's the unevenness that we'll see when it comes to criminal sentences. After each side's attorney either uses that option or doesn't use that option, the judge then, not the jury, but a judge would decide the sentence based on this PSI, based on the seriousness of a crime, and based on any mitigating and aggravating factors. And those factors should be in the PSI or the PIR, and that should be something the attorneys reviewed. But those are all of the factors that the judge will take into consideration when making their discretionary decision. And we call it informed discretion in sentencing because they have gotten all this information first. Now, over here, you'll notice that this is going to be true for every kind of a case except for a capital case. In a capital case where the death penalty is on the table as an option, the Supreme Court has made some decisions. All right, in a capital case where the death penalty is an option, and that's in many states in the United States and in the federal court system, we don't use a judge to decide that sentence anymore. And I'm going to show you how that works. So in 1972 to 1976, the United States actually had a temporary hiatus, or they put a pause button on all executions in the United States. There was an important case, which you do need to know, Furman versus Georgia. And the ruling was that the current, meaning at the time of 1972, the current process of sentencing people to the death penalty violated the Eighth Amendment of cruel and unusual punishment. So many states actually had to come up with a new system. And basically what happened is the Supreme Court, in this ruling of Furman versus Georgia, and then in the subsequent case in 1976, basically said, until we find a better way to sentence people to death, we're not going to execute them, because this way of sentencing where the information goes to a judge and then you have a single person deciding life or death for another single person, we're going to cut that out. So what they came up with is something called the bifurcated process. You do need to know that bifurcated process. Here's what it looks like. It's over here on the right. Stage one is the criminal trial. At the trial of a capital case, so if it's a capital offense, in a jurisdiction that allows for capital offense, the trial part, when they're looking at the verdict, instead of guilty or not guilty, they're looking at guilty or not guilty of a capital offense or guilty or not guilty of a lesser offense. So if the person is found guilty of a capital offense, they're going to move forward in this bifurcated process. But it's possible that the jury could find them not guilty of that offense, or they could have a third option of finding them guilty, but guilty of a lesser offense rather than a capital offense, which would mean that that person is still guilty and would receive a sentence, but that sentence would not be the death penalty or could not be the death penalty. So if this happens, they get no death penalty. If they're found guilty of that capital offense in a jurisdiction that allows it, they would move on to stage two of the bifurcated process. And bifurcated, think bicycle, 2 stages, 2 steps, 2 wheels. All right. In stage two, a sentencing hearing takes place. And what this means is instead of a judge giving capital sentence, the decision is given to a jury. And this jury is going to decide, do the crime circumstances justify the death penalty for this particular person in this particular crime? So this jury then is deciding yes or no on execution or life in prison without parole. We're going to find out later that there are some people who would not qualify for this, but we'll talk more about that in a future lesson. But this bifurcated process, stage one is the trial jury, stage two is the sentencing jury. This is the only time or the only kind of case in which a jury gives out the sentence. All other cases, it's decided by a judge, and the judge has to make that informed discretion. So then the question comes up of how much discretion does a judge actually have in giving the sentence? Can they go with their gut? Are they restricted in any way? And I'm glad you were thinking that because, and I'm sure you were, because that's the next thing I'm going to tell you about. There are 2 types of jurisdictions when it comes to sentencing. There's indeterminate and determinate. And basically what you want to think about is, was the sentence determined by the legislature? You got to go to your government learning and your 3 branches of government, your executive, your legislative, and your judicial. Sentencing is done through the judicial branch. But in indeterminate jurisdictions, states, counties, whatever, where this is considered where a legislature is going to remove the determination from the they're going to remove that determination from the legislature and turn it over to the judicial branch. And they're going to prescribe a range of time or a range of sentences that a judge can choose within, and basically then say, all right, judge, if this is the crime that's committed, let's say it's a class 1 felony. If it's a class 1 felony, you can give a sentence anywhere from this extreme to this extreme. Anything in there based on the particulars of the crime is up to you. And then that's described within the law itself. And then if the person is sentenced to prison or any sort of imprisonment after the judge is given the sentence, later on, a parole board would decide whether or not to release the person after reaching a minimum point of serving that sentence. That's indeterminate jurisdiction. Determinate jurisdiction would be a different state or county or et cetera, where the legislature has determined, they have predetermined the sentence. So if somebody commits a class 1 felony, they have one option for a sentence. That's it. You do a class 1 felony, you get this sentence. That's it. And the release then from corrections would only occur after the fulfillment of that sentence. A lot of times we're talking about imprisonment, so it would be fulfillment of that time minus any what's called good time. Good time used to work in such a way that, let's say you served 1 day of a prison sentence and you behaved yourself, you didn't get in trouble, etc. That means that you would get 1 day's credit of good time. So let's say instead of serving 365 days, let's say you had a year, okay, that you had to serve. If you served day 1 and you did really well, you obeyed the rules, you're good to go. Then that then would give you 1 day off of your 365-day sentence. And then day 2, you do a good job, you behave yourself, you follow the rules, that would give you 2 days off, your 365 days. So now you'd be sitting at 363 days. And what that did then is that if a person behaved themselves, for lack of a better description, they could serve a prison sentence without, or a jail sentence, without disobeying the rules or getting into trouble or fights or causing any problems. And they would, if you do the math, theoretically, a person could serve half of their sentence because they'd spend the first half behaving themselves, and each of those days would count as credit time off of their sentence, which would mean then that if a sentence was given, it could really, in reality, translate to half of that. So if a person's given 10 years, they could serve 5 years with that good time. And that was creating a problem. So back in 1995 in Illinois, there was this new law or set of laws that was passed called Truth in Sentencing laws, which required there to be, and again, it's not creatively named, there to be truth in the sentencing. So a person then who is considered a serious offender wouldn't be able to receive more than 15% off their sentence with good time rewards. So basically, if a person was sentenced to 10 years, they would have to serve at least 8.5 years of that sentence before their good time would kick in. So it made it so that instead of being sentenced to 10 years and only serving 5, you'd be sentenced to 10 years and at least serve 8.5, which is a whole lot closer to 10 years than 5 years is. And so they kind of felt that there would be truth then in the sentences that were given. So you'll need to know those truth in sentencing laws. You don't need to know when they took place, just know it happened before you were born. Now, I know that was quick. Hopefully it made sense to you. Here's what I want you to do with that information. I want you to evaluate, and you're going to have a Canvas discussion on this. First of all, what do you think are some of the benefits and some of the drawbacks of indeterminate sentencing jurisdictions? What's good about it? What's bad about it? Same thing for determinate sentencing. What's good and bad about the legislature saying you do this type of crime, you get this one sentence? Then I want you to talk about what are the benefits and drawbacks of good time. What's good about having that as an option, and why is that also problematic? You're going to enter that discussion. Oops. If you go down here to the sentencing types, benefits, and drawbacks discussion, and you're going to post your answers here in this discussion. Good luck to you, and I will hopefully talk to you soon. Bye.